Good morning to you all. The respective chair, Dr. Chamila Talagala, and all the other distinguished guests and the paper presenters and all of you who are present today. I'm going to present my findings on the protection afforded to well-known trademarks in Sri Lanka, a critical analysis. So the outline of my presentation consists of the introduction, then the research problem, research questions, research objectives, research methodology, findings, results, recommendations and conclusions, acknowledgements and the bibliography. So as you can see, trademarks are very much a valuable asset when it comes to the respective owners of the trademarks, and especially you can see in the picture some of the well-known trademarks in the world. Like you don't need to even say the words that are in there, you just recognize what that mark stands for. Like it has been found out that for certain entities, and especially with regard to Coca-Cola, the trademark Coca-Cola is the third most known or the second most known trademark in the world after Santa Claus. So the value of the Coca-Cola trademark is it far exceeds the total assets of the Coca-Cola company and its secret recipe. So as trademarks or trade names will help the customer to distinguish the good services which have brought him or her the greatest satisfaction from those which have not. And in this case of L'Oreal versus Bleu, the modern function of a trademark was stated to be just more than guaranteeing the consumers the origin of the goods or services, but they found that, but also it has other functions, including in particular that of guaranteeing the quality of the goods or services in question and those of communication, investment or advertising. So the trademark itself will help a person without making the trouble of finding another product when he or she has experienced the quality and the goodness of a particular brand. And the research problem for this is the prevailing law on well-known trademarks in Sri Lanka sufficient to protect the interest of the owners of those trademarks. And these are the research questions. What is the current status of the law relating to protection of well-known trademarks in Sri Lanka? What are the international obligations with regard to the trademark laws? What are the protections afforded to well-known trademarks rather? What are the exclusive and additional protections afforded to well-known trademarks? And what are the limitations of the current system? And what are the required changes and possible recommendations? And the objectives to discuss the current status of the law relating to the protection of well-known trademarks in Sri Lanka, then to describe the international obligations of Sri Lanka with respect to trademark laws, to explain the protections afforded to well-known trademarks, to evaluate the exclusive and additional protections afforded to well-known trademarks, to analyze the limitations of the current system and to comment on the required changes and possible recommendations. And this research methodology, this is a qualitative research. This research is conducted using qualitative method, where it uses the primary legal sources of the Intellectual Property Act number 36 of 2003, the TRIPS agreement and the decided case law. As secondary data, it uses the commentaries given on the relevant sections by reputed authors, while including Dr. D.M. Karunarathna in particular. So when it comes to the finding and the results, the law relating to trademark in Sri Lanka, I use the word mostly governed by Intellectual Property Act, because in particular trademarks which are registered enjoy a higher degree of protection than ones that are not. And with regard to unregistered trademarks, they can still be protected by the tort of passing off or under unfair competition law recognized in the Intellectual Property Act, where contrary to honest practices are outlawed. And then we come to the question, what is a trademark? Now this is a definition given in the Intellectual Property Act itself. Trademark means any visible sign serving to distinguish. So this is very important. It has to have the characteristic of distinguishability, the goods of one enterprise from those of another enterprise. And again, I have emphasized the worth of a trademark far exceeds the total assets of the company owner of the trademark, the prime example being the Coca-Cola. And then we come to the question, what is a well-known trademark? In this regard, the IP Act does not provide a definition for the term well-known trademark. However, under section 104(2) lays out the criterions for determining whether a particular mark is well-known or not. These criterions are basically a copy from the WIPO recommendations that were given in 1999. And in this case, McDonald's Corporation versus Joburg Drive-In Restaurant, the South African court held that the term well-known should be tested on the basis of whether sufficient people knew the mark well enough to entitle it protection against deception or confusion. But again, this we cannot say is a good definition. But when you look at the Indian Trademarks Act number 47 of 1999, it defines the term well-known trademark in section 2ZG as well-known trademark in relation to any goods or services means a mark which has become so to the substantial segment of the public which uses such goods or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering the services between those goods or services and a person using the mark in relation to the first mentioned goods or services. Then when we come to the Sri Lanka's international obligations regarding well-known trademarks, it is very clear that Sri Lanka is a member state to both the TRIPS agreement, the agreement related the agreement on trade related aspects of intellectual property rights, and the Paris Convention on the Protection of Industrial Property 1883. But Sri Lanka is not a member state to the Madrid Agreement concerning the international registration of marks or the protocol relating to the Madrid Agreement. Both the latter agreements deal with the international registration of trademarks, where the trademark owner can get his mark registered in several countries with a single application. But unfortunately, as we are not a member to those instruments, a respective owner of a trademark cannot file a single application to get it done in Sri Lanka. And when we come to the protection afforded to well-known trademarks in particular, at the registration stage, the IP Act of 2003 does give the protection at the registration stage to a well-known trademark in a negative form, and this is done according to section 104 of the Act, which in general tries to protect the interest of third parties regarding registration of trademarks. In subsection 104D states that when a trademark that is presented for being registered is identical with or misleadingly similar to or constitutes a translation or a transliteration or transcription of a mark or trade name which is well known in Sri Lanka for identical or similar goods or services of that third party, irrespective of the first well-known mark being registered or not. So this is the only instance that a well-known trademark is given a special kind of protection at the initial stage, where even the mark is registered or not, if a proposed mark is going to be similar to a well-known trademark, the registration may be denied. However, in the case of Coca-Cola versus Pet Packing Limited, what happens was a Sri Lankan company introduced the soft drink My Cola, and then there was a claim brought by Coca-Cola alleging that there was a misleading similarity between the two marks, but the court did not recognize this as such, and the court stated that as the Coca-Cola mark is well known in Sri Lanka, even a very small change would enable the consumers to recognize it as such. Then under the IP Act of 2003, only the registered owners of a mark are given the opportunity of enjoying the exclusive rights that comes with registration. Rights granted under these are not time barred like patents, copyrights, as it runs eternally. According to section 121(1), a registered owner has three distinctive rights, which includes to use the mark, to assign, transmit the registration of the mark, to conclude licenses contract in respect of the mark. Section 121(2)(a) enables registered owner to stop others from using the mark if it is likely to mislead the others, and this likely to mislead was interpreted in Thilakarathna versus Majid. The registered owner is given a broader protection under section 121(2)(b), where the third parties are precluded from using the registered mark without a just cause and in conditions likely to be prejudicial to the interest of the registered owner. These are some of the additional protections which are afforded to trademarks in the form of civil and criminal proceedings that could be brought in. According to section 161B, clearly state that provisions of this section shall apply independently. Sorry, this is regarding, I beg your pardon, this is regarding the unfair competition law. So unfair competition law is an additional protection afforded to all the intellectual property rights irrespective of the rights that are already been provided, and section 161B clearly states that the provisions of this section shall apply independently of the and in addition to the provisions of the act. Is the time up there? 2 minutes. So I will come to what are the shortcomings with regard to the protection of well-known trademarks in Sri Lanka. First of all, the term has not been judicially interpreted in the Sri Lankan courts. The second one is protection afforded to trademarks only if they are registered, and this is very technical. Again, if the mark is only registered, then you are going to be afforded with the necessary protection. The fact whether a trademark is well known or not makes no difference. A problem would then arise as to whether or not a well known again trademark which is registered Thilakarathna mark in a union country which is not visible sign in a traditional sense is capable of being registered, as the Sri Lankan law requires the visibility or the visual perception. And if I come to some of the recommendations that I would like to mention, first of all, providing a definition of a well-known trademark, then allowing for registration of non-traditional trademarks when they have been registered in a union country. This we can easily do, becoming a member to the Madrid Agreement so that an owner of a mark can get his mark registered through a single filing of an application for multiple countries. And in concluding, regarding the Sri Lankan law, most of the provisions are TRIPS compatible and are in conformity with the Paris Convention. However, with regard to protection afforded to well-known trademarks, the law should still be revisited. Thank you very much.